All right, I'll get us started. Hello, everyone. I'm Parthivi Das, Executive Director of C2HR, and I'm excited to welcome you to today's HR Learning Series. C2HR is able to provide quality educational programs for our members, like today's learning series, thanks to the generous support of our 2025 sponsors, ZRG and Kelley Drye. The next slide, please. We sincerely appreciate your support. Today's topic focuses on the impact of the new administration on EEO policies. This HR Learning Series will focus on current changes and provide practical considerations for employers navigating these changes. We would like today's webinar to be interactive and invite you to post questions and comments in the Q&A box throughout the discussion. SHRM has approved the webinar for 1 CE credit, and the credit will be emailed to you after our event. Next slide, please. Today's featured speakers are with Kelley Drye. Barbara Hoey is the partner in the Labor and Employment Practice Group, and Mark Konkel is partner and chair of the Labor and Employment Practice Group. Mark and Barbara, we can't thank you enough for taking the time today to talk to our C2HR community. Thank you for your insight, and I'll turn it over to you.
Okay. Good morning or good afternoon, everyone. As you heard, my name is Barbara Hoey. My partner, Mark, and I together are practice exclusively labor employment law, have been doing it for in excess of 25 years. And I will say that this last 2 months has been probably the most shock with change that I've ever seen in my several decades of doing this. So what are we going to try to cover today? We only have an hour, so we really are going to touch on a lot of topics that frankly, in and of themselves, could be an hour-long presentation. But we're going to start with what has happened at the EEOC. We have a new chair and how they are not moving forward, given the termination of several of their commissioners. Then, of course, we have the executive orders, of which there are, last count, 76, 78, if you count. There's another one probably today. But there are a few key that affect the employment area, and that's what we're going to focus on. What has the EEOC been doing in light of the executive orders, withdrawing claims? We're also going to cover religious accommodations, and also reverse discrimination. Those are two focuses of the Trump administration. And then throughout, and lastly, considerations for employers, how to really be practical about this. We encourage questions, so we know you're out there. Please use the Q&A box to submit them, and we will either get to them or often there's something we're coming to. So what's the big picture? 100 days in, the president has upended years of legal precedent, and more is likely going to follow. The executive orders, as I said, are many, but have any of them actually changed the law? I mean, these are some of the things we're going to talk about. What are the executive orders that you need to worry about, you as an employer, you as a company? What are the courts doing? There are millions. There are multiple lawsuits filed, but we're going to try to drill down to, frankly, what are the ones that matter right now and what are the ones you should be watching? How is this going to affect your business? At some degree, it depends on what sector you're in, but there are certain commonalities that I think apply to every single business. And what should you be doing? How should you in the HR community be reacting? And there is a lot that you can be doing and should be doing to get ready for the changes that have already taken place and changes to come. And I will now turn it over to Mr. Konkel.
Thanks, Barbara. Okay, so we're here to talk about what the EEOC is up to and will be up to and how that interplays with the executive orders. So let's just start with the basic view of the personnel currently of the EEOC and why that, beyond the obvious, is important. So the very first move upon Trump's inauguration at the EEOC was to appoint a new chair. Now, there is some history here. And so Andrea Lucas, the new chair of the EEOC, had always, in reaction to guidance to some maybe more considerate like progressive moves or movement of the EEOC, had always been sort of a dissenting voice, and sort of consistent with that dissenting voice. And you can read this quote for yourself, but I just want to pick out a few phrases here because it's really telling. Think about what we, in HR, in the legal industry, in employment law, what Barbara and I have always thought the role of the EEOC is. Well, according to Andrea Lucas, its role now include rooting out unlawful DEI motivated race and sex discrimination. There's some argumentation going on in there, right? DEI is paired with the word discrimination. Protecting workers against anti-American, national origin discrimination, defending the biological and binary reality of sex. So think transgender rights. And protecting workers from religious bias and harassment, and then otherwise remedying other areas of under enforcement. So what does that mean? What that means is the EEOC at this point has a mission that takes what we always understood as its traditional role, which was, frankly, centered on protecting the rights of historical minorities, people who are underrepresented in workplaces, and promoting almost the photo negative of those interests, right? So what is Andrea Lucas's authority to do this? What's the authority of the EEOC in general? So the agency develops it, approves commission policies. As many of you know, it investigates individual charges of discrimination and authorizes the filing of discrimination lawsuits on the EEOC's own behalf. Now, obviously, it makes decisions about which employers, which acts of alleged discrimination, how big of a problem it intends to pursue in its own litigation. Otherwise, it handles a lot of EEOC charges of discrimination. It doesn't make or pass laws, but for obvious reasons, it's very influential. The commission itself, you hear the EEOC, C stands for commission. There are actually 5 commissioners. And right now, there are currently 3 vacancies. What does that mean? It means technically, because a majority is not constituted in the commission itself, it means that the commission doesn't necessarily have authority to act. However, don't take too much comfort in the fact that if the EEOC targets your company or is taking actions that may be of concern to you, that the fact that it doesn't have a quorum stymies it, because it has a great deal of practicability to act through its general counsel. Andrew Rogers, a Trump appointee, has been appointed as acting general counsel, and he has the additional authority to act on behalf of the EEOC absent a quorum. So what does that mean? So the EEOC had 4 commissioners. That would have been a quorum. But on January 28th, so 8 days after the inauguration, Trump fired, and this has been very controversial, Democratic commissioners. That is, commissioners who were appointed by Democrats as presidents, Jocelyn Samuels, Charlotte Brown. Those terms, or their terms, would have ended sometime into the future. Samuels, summer next year. Burrows, not until the summer of 2028. Trump also fired the general counsel, Kelley Drye. Her term was to end in 2027. So that in and of itself, in an administration that's all about breaking eggs right now, those terminations themselves broke from decades of legal precedent and practice, frankly, where you would leave commissioners and the general counsel in place until replaced when the terms ended up, and leaves the EEOC without a quorum. So what does that mean, though, right? That, notwithstanding the fact that the EEOC can act through its general counsel, what does it mean that the EEOC is operating without a quorum? Well, the EEOC has kind of rushed to fill that void, at least in terms of public perception. And earlier in February, the EEOC published an updated memorandum attempting to address, kind of all of these open inquiries about what's the EEOC's authority even to act right now. And it emphasized that the EEOC, this is the quote, remains open for business, and it explicitly pointed out that the fact that the EEOC is operating without a quorum right now would not prevent it from currently pursuing litigation that it was engaged in. Now, we're going to see evidence that that is not the case later on, if the EEOC has actually acted to withdraw lawsuits that would have been pursuing a more progressive agenda. That same press release early in February also claimed that the EEOC would continue to file lawsuits. So leaving aside the question of pending suits, would continue to file lawsuits and function absent a quorum. There is no evidence yet that the EEOC is actually going to file lawsuits, but it maintains, and frankly, it's probably too soon to tell whether it will continue to file lawsuits, even acting without a quorum. Okay, so as I said before, that's the EEOC that we're dealing with now. It's pursuing a radically different agenda, which ties more or less directly into what Barbara is now going to address, which are Trump's employment-related executive orders. So over to you, Ms. Hoey.
Thank you, Mr. Konkel. And just to finish off on the EEOC, they did appoint a new general counsel, an acting general counsel, a guy named Andrew Rogers, who not coincidentally was the chief counsel to Miss Lucas when she was just a commissioner. So clearly he, and in many ways, the general counsel will drive the agenda. So he probably hasn't had time. He's only been in the job about a month. But when he has time, I'm sure he will be trying to pursue lawsuits. So where are we with these executive orders? Well, as Mark was indicating, Ms. Lucas made her position clear when she was before the change in the administration. No such thing as reverse discrimination in her view and in the view of the new administration. There is just plain discrimination. And what they've done in order to advance the agenda of, combating that discrimination, you've got to really go back to 2023, which is when it first started. The Supreme Court decided what many people call the Harvard case, Students for Fair Admission, in June of 2023. And that was the case that decided that affirmative action at colleges, which up until then was legal under a prior Supreme Court decision, was no longer legal. It overturned longstanding precedent, but the case only applied to universities. The plaintiffs' bar and the sort of conservative movement, however, took up the SFFA decision. And in the year and a half before President Trump's election, we're advancing an agenda of demanding that schools, not just schools, employers, large companies, airlines, you name it, eliminate DEI. And they sued. They sued a number of entities. And the organization you see there, America First Legal, is headed up by Stephen Miller, who now is one of President Trump's key advisors, I believe head of Homeland Security, but a lot of people believe behind the scenes, an architect of his domestic policy. So if you just look at what they did, it gives you a very strong indication of what we're going to be looking at going forward. So, however, in 2023, as all of this fighting was going on, the EEOC made a point of telling private employers that DEI programs were still legal. Well, position has changed. So as many people know, literally on day one, President Trump returned to his office after being sworn in and signed somewhere around initially 50, and now we're up to, I think, over 80 executive orders. We've picked out the ones that had the most immediate and then potential longstanding impact on employment law. And they are listed here. Ending radical and wasteful government DEI programs, ending illegal discrimination, restoring merit-based opportunity. Those both relate to DEI. Defending women from gender ideology, restoring biological truth. That relates to transgender and LGBTQ policies. Initial rescission of harmful executive orders, that was also part of the DEI agenda, and limiting lame duck collective bargaining agreements. We're not covering that today, but these are I believe, these are the 5 that you need to look at most as an employer. So what is an executive order? I think a lot of us hadn't even sort of focused on them before this administration. So it's simply an order written by the president, directed at other branches of the federal government under control of the executive branch, does not require congressional approval, cannot be reversed by Congress, but can be reversed or modified by the courts. What it is not a law. It is not a statute. So it cannot violate a law. However, it can ignore, skirt, try to expand existing law. It does not change state or local laws, and it is not self-funding. So if something was going to require funding by Congress, the executive branch would have to go to Congress. And those are very important things to remember as we are looking at these executive orders. So the first one we're going to focus on is the Ending Illegal Discrimination executive order. And what that executive order did is it rescinded 7 older executive orders, including one that went back to the administration of President Lyndon B. Johnson, which had prohibited federal contractors from discriminating and established the OFCCP, established affirmative action. That was rescinded. The OFCCP, as best we can tell, has more or less ceased to exist or ceased to have a purpose because affirmative action programs are over. And the DOL was ordered to immediately cease promoting diversity. But again, this executive order did not alter existing law, still require affirmative action for disabled individuals and veterans. And of course, it doesn't alter existing case law, which is something to remember. So the other thing the executive order did was there was an explicit warning to private employers. Even though the EO couldn't focus on private employers, what the executive order said was federal agencies were ordered / directed to target and then investigate at least 9 employers or companies under their jurisdiction. So a lot of people think about 9. It's actually potentially more than 9 because each agency can look at 9. The Attorney General was directed to enforce the civil rights laws and take, quote, appropriate measures to end illegal discrimination and preferences, including DEI. That's been called the enforcement threat provision. And to some degree, the president has already started to do what was threatened. So there was an executive order issued just last week. Some of you may have read about it. He issued an executive order directly against a private law firm, a firm called Perkins Coie, that does a lot of work in Washington in the federal sector, because of the firm's representation of Hillary Clinton and work they did in 2016 in connection with that election. The order accused the firm of racial discrimination, and specifically directed that they have their security clearances revoked, certain government access revoked, and specifically directed the EEOC to investigate the firm. It's quite a jarring turn of events because I can't think of any time ever I don't know that anyone knows of any time when an executive order has actually been issued directly against a private business. And immediately the EEOC changed course. So they erased within days of the inauguration from their website different pieces of guidance, removed all guidance on Bostock. Bostock is the case where the Supreme Court recognized the rights of the LGBTQ, removed guidance on discrimination with use of AI, kept what had been spent many years developing, which is 2023 sexual harassment guidance, but there are going to be changes there because Andrea Lucas indicated back in 2023, there were aspects of that guidance that she did not agree with. So with the issuance of the executive orders, the agency has immediately changed course. And the courts, however, are acting, which Mark is going to take up.
Yeah, thanks, Barbara. So as Barbara pointed out, what is an executive order? Certainly the executive, the president, has the ability to direct what federal agencies are doing, right? But even within that realm, as Barbara says, the EEO executive order is not a law. Who gets to say what the law is and whether, in this case, presidential actions, executive orders, other presidential actions are consistent with what the law permits or requires? Well, that's the courts. In this case, federal courts, all the way up through intermediate appellate courts, ultimately all the way up to the US Supreme Court, if appeals or disputes get that far. So this is the sort of the marquee case. This is the case. There's a lot of pending litigation right now. A variety of lawsuits have been filed, not just with respect to employment-related executive orders, but this is the one in which an injunction has actually been issued. And on, as you see there, February 21st of this year, a federal judge in National Association of Diversity Officers in Higher Education v. Trump issued an order temporarily blocking certain provisions of these initial executive orders. So what was challenged were really 3 things. A so-called termination provision, which requires termination of equity-related grants or contracts. All of this is aimed at DEI. a certification provision that requires each agency head to certify that the federal contractor, in this case, so these are companies taking federal money, does not operate any DEI programs, and the so-called, similar to what Barbara just pointed out, the enforcement threat provision instructing the Attorney General to take appropriate measures to encourage the private sector to end illegal discrimination, including allegedly through DEI. So why did the court strike it down? The reasons are all kind of common sense. The main ground, there are really two grounds, Fifth and First Amendments, right? So there's a Fourth Amendment challenge here, due process. And we all hear about due process of law. Here's what it really kind of boils down to in plain English. If we can't understand what a law or some purportedly binding legal requirement means, it fails for unconstitutional vagueness, right? You've got to know what you can't, a law has to be clear on its face, what you can do, what you can't do. So here, as the court wrote, the parties have to, quote, know what is required of them so they can act accordingly. That the law has to tell parties what to do and what not to do. The order and related enforcement guidance doesn't even tell you, as the court pointed out, what illegal DEI even is, right? So it refers to DEI that unlawfully discriminates. It's certainly possible to devise, maintain, promote a DEI program that does not, whose intention is not unlawful discrimination, doesn't result in unlawful discrimination. The order just outright bans it. And in that sense, but in telling people stop your illegal DEI programs, that naturally begs the good faith question, could you just tell us what's an illegal DEI program? It also fails on First Amendment grounds as a content-based restriction. And here's what that basically means. As you all know, the First Amendment happens not to bind private employers. It certainly does bind the federal government. Here, the president's part of the federal government. The executive order orders what it orders with respect to DEI. But when you think about what that's actually doing, it's telling private entities with government contracts, they can't have a DEI program or otherwise they risk losing federal funding. So even if you think that your current program is lawful, you're subject to enforcement actions, right? Civil compliance actions for engaging in protected speech protected under the First Amendment. In other words, our DEI policy is an expression of our views as to diversity, equity, and inclusion. By the way, our policy is not a let's discriminate policy. And you can't tell, the federal government can't tell private entities how to speak. Therefore, this order is a content-based restriction. The judge added to this a nationwide injunction on February 23rd. So just yesterday, the Trump administration went back to court in a 4-page motion to the court saying, can you tell us what you mean by, how far your injunction extends? The court sort of responds starkly, what don't you understand about nationwide injunction? This executive order is barred right now from operation across the whole country. That issue is obviously going to go up on appeal. And whether it goes to the Supreme Court or not is yet to be seen. But right now, that executive order has been enjoined. That is, it's being prevented from being enforced by this court decision. So what is the future of DEI under Trump? And I think, Barbara, you're going to take over here. Is that right?
Okay. I believe so. So look, obviously, the federal administration right now does not favor these programs. And you start with the EEOC is empowered to enforce the law and is empowered to bring lawsuits. They have huge budgets, but they don't have unlimited budgets. They cannot sue every company in the country. When they do sue, however, they can inflict a lot of pain and discomfort on a company. They can also commence investigations, which get very, very expensive. So whether you're sued or you're just the subject of an investigation, you do not want to get in the crosshairs of the EEOC. If you settle a case with the EEOC, as opposed with a private plaintiff, those are public settlements, and they will often put them up on their website as an example for others of what the settlement was. They can subject you to a consent order, which means they are going to supervise your HR policies going forward, and they have other enforcement authority. So you do not want to get in EEOC's crosshairs. Other agencies can also act. As an example, the FCC is now investigating Costco over their DEI policies. And private plaintiffs can also sue. And Mark is going to talk later about reverse discrimination. And frankly, excuse me, I think the risk from private plaintiffs or private groups at the moment is at least equal to the risk of a government investigation, just because of the resources of the government. And because this is now a claim that is in vogue. And the government is already acting. I mean, again, some of you might have seen this again just last week. It was either Thursday or Friday. The DC Attorney General, I believe his name is Martins, wrote a letter to Georgetown Law School stating that they were not going to hire law school graduates of Georgetown if Georgetown did not remove all DEI from its policies and curriculum. Is really quite shocking. And the response, a letter from Dean William Traynor, who I'm proud to say was the dean of Fordham when not when I went there, but before going to Georgetown, very well written, and said that, again, First Amendment protection. It really goes back to what the Maryland judge found in the case that Mark talked about, that a university has a right to determine its own curriculum, how to deliver that curriculum, and it is a violation of the Constitution and to the university's mission to attack the university. Now, Georgetown hasn't sued, maybe because there hasn't actually been a damage yet. Like, you don't know that a student has applied for a job and been rejected. So there might not be an actual case or controversy to sue over, but it's a really shocking move by the federal government. And I think a move intended to scare private employers, right? If you're going to go after the lawyers, then what are you saying to the entities that would be their clients? So what can you do and what you should be doing? Okay, you can still support the concept of a diverse workplace. You just have to be careful how you apply your policies. You should not be awarding promotions, internships, scholarships, training programs, grant programs. They have to be open to all. It's that simple. The scholarship should be open to all. The training program open to all. Interviews open to all. Affinity groups, a lot of our clients have done this, open to all. You know, if you want to join or sit in on the meeting of a particular affinity group, you're welcome to do that. And actually, that was our policy before. That was Kelley Drye's policy before. What you do not want to do, and you really need to do, and you should have maybe already or be doing an audit of websites and policies. You don't want to be using numerical goals or quotas as per hiring of any particular group. That actually should not have been happening before. What's surprising to a lot of employers is this doesn't really change the law. The only employers that were allowed to do affirmative action were a select group of government contractors and universities. So this doesn't change anything. You don't want to tie diversity goals to compensation. That was something some companies were doing before in a way to push executives to hire diverse employees. I think that is actually a bad idea under this current administration. And again, back to the basics. Make decisions based on merit and qualifications, which doesn't mean that you have to now have a workforce that all looks alike. Training, I think training can and still should be mandatory. The law hasn't changed in your state. The law hasn't changed in your city. We are not advocating discrimination, and no one would. So your employees, your executives still need to be trained about handling diverse workers and making sure that everyone is basically judged based on their qualifications. I think review with the trainers and review the training to make sure that there's nothing that would be considered, anti or to DEI. Consider exemptions. This is a point. If an employee comes to you and says, look, I don't want to attend this discrimination training. There have been cases, actually, I'm going to talk about a case a little later that just came out of Pennsylvania. All right. If you said this to me a year ago, I would have said, make him sit through the training, make her sit through the training. If this is somebody that you think is going to make a charge, go to some agency or get a lawyer, you know what? Exempt them from the training, make them re-sign your policy, or let them watch the training online. Don't make them sit in a live training. The momentary pain of letting someone miss a training is far less expensive than getting investigated or getting a lawyer's letter. And I don't know if Mark disagrees, but I would just let him skip it. And
Yeah,
avoid.
provided that you're saying to the employee, okay, don't sit through the training. Here's our policy.
Yeah.
Sign that you've read it,
And I would really avoid disciplining people for not attending training. I think that should be avoided at all costs. Again, re-sign the policy. Here's the policy. We're sorry you're not going to attend the training, but no, we're not going to discipline you. And remember, of course, the backlash against DEI is never and should never be viewed as a license to discriminate against those who are diverse. Your employees and your customers still have to be considered, and there is a lot of merit to having diversity of thought when you're running a company and establishing policies for your company. And
okay, so I'm going to pick up on a point that Barbara has touched on briefly or foregrounded, which is so-called reverse discrimination. Now, as with everything here, there's an historical context. We've talked about Andrea Lucas as the new EEOC commissioner. She's the new EEOC chair, but she's actually been on the EEOC as a commissioner since 2020. And back in April of 24, she was speaking at a law firm conference in Las Vegas, and that turned out to be, so we have a commissioner. She emphasized that she was speaking in her personal capacity and not officially in her capacity as commissioner, but she was expressing her views of various elements of anti-discrimination law. And that yielded a bunch of very, very interesting comments, right? So Lucas shared her focus on addressing what she sees as, quote, I was just looking for the quote, culturally acceptable biases. So that's a reference to preferences to hire diverse people, right? Meaning essentially non-white, non-gay, non-LGBTQ, right? Male, culturally acceptable biases as part of DEI programs that would disfavor, frankly, groups that have always enjoyed cultural advantages, right? She also said, and this goes back to one of the quotes that Barbara looked at before, there's no such thing as reverse race or sex discrimination or civil rights laws. There's just discrimination, right? And she also put in comments about, at a time when a lot of employers were coming out in support of Black Lives Matter, and there were some legal kerfuffles arising out of that, employees saying, they disagreed with employers, showing support for that movement. She also kind of offered the unsolicited advice, now maybe a little bit more relevant that she's the chair, do employers really need to be weighing in on every cultural issue, or should they be running their businesses? Now, what's interesting about all of this is that regardless of kind of where you fall on the political spectrum, a lot of what she said is actually right as a matter of law, and frankly, as a matter of something that I don't know if Barbara would disagree. I suspect since she and I share the same brain in a lot of ways that she would not disagree. We don't know that employers need to be going out on political limbs all the time in a way that might provoke employees instead of simply focusing on the running of businesses. And that's not because of any deterrent effect of the current administration. It really is because every time you're doing that, you may be provoking somebody who may use anti-discrimination laws as a framework to kind of prosecute their grievances against you. But
Mark, I 100% agree. There was actually an article just maybe today in the Times about the fact that many universities are choosing not to comment on issues in the news. Whereas a couple of years ago, this university commented on the whatever event was happening at the moment because they simply don't want to inflame one side or another. So they don't comment. Focus on your mission, which is educating students. Focus on business, which is selling beer or selling milk or selling furniture or whatever it is you're selling. Focus on DEI to the extent it's better for your business. But no, you don't need to get out front and comment on things and take a stand. And I think a lot of your customers and employees would understand when you choose not to.
Yeah. Well, or selling legal services, right? As Perkins Coie could point out. Actually, for the last couple of months, Barbara and I are considering maybe going into the selling of beer business, but we'll keep you posted on that. So, is there such a thing as reverse discrimination? The short answer is, again, forget politics for a second. No, there is literally no such thing as reverse discrimination. And here's what I mean by that, not in a cultural sense, but go back to Title VII, right? The mother or the father not to use gender-driven terms, of essentially all the anti-discrimination statutes that followed at state and federal levels. It prohibits discrimination, that is treating one applicant or employee differently than another because of, caused by, that person's membership in a bunch of protected categories, which has since expanded to include a lot more than just this. But take a couple of them, right? Race and sex. The statute doesn't say it's unlawful to discriminate against Black applicants. The statute doesn't say it's unlawful to demote female employees because, you know, in the former case they happen to be Black, or in the latter case they happen to be female. It just says, look, if you've got a race or if you've got a sex, and we all do, it is not a legitimate way to make an employment decision to decide on that basis. And I don't think anybody could disagree with that. So when, you know, it used to be a bit of a novelty, frankly, you know, I go back 15, 20 years, right? When, you know, a person who looks like me would file a lawsuit saying, I think that I've been disfavored in promotional opportunities because I happen to be a white male, right? Defendants would move to dismiss those lawsuits saying, Mark is not your typical plaintiff. And it was true that Mark was not your typical plaintiff, but Mark was making an allegation that, if true, would violate Title VII. If it really was true that I was being, you know, disfavored in promotional opportunities because I happen to be white or I happen to be male, and that's the reason why I was disfavored in that way, that would violate Title VII just as much as anything else. Now, historically, that's not the kind of, I'm going to call it, you know, air quotes, social injustice that Title VII was meant to address. And we all know that. But the statute says what it says. Under Title VII, it's all just discrimination. So what is actually being reversed now? It's a cultural thing. Lawsuits by individuals who aren't part of historically disadvantaged groups, are now, you know, who were sort of members of, we'll call them majority groups, now feel more empowered to pursue lawsuits. And that's very much consistent with the EEOC's state admissions and some of Chair Lucas's comments about trying to combat so-called reverse discrimination. So Barbara was talking about these legal challenges, even when the EEOC was still maintaining that, for example, DEI programs are perfectly lawful. Since that time, and certainly now even more, there's been a significant increase in reverse discrimination. And one of the reasons for that is, forget the Trump administration, that foregrounds it that much more, right? But you might all remember the 2023 decision in Students for Fair Admission v. Harvard. What Students for Fair Admission challenged were admissions practices in institutions of higher education that used race, it happened to be race, as an explicit factor in admissions decisions. That case held that was unlawful. But even though that case was about higher education and not employment, there's no analytical distinction between what that case was saying, which is essentially there's no such thing as reverse discrimination, right? And if you make admissions decisions using race as a conscious factor, it violates federal law. No analytical distinction between that rationale in higher education and the same rationale in employment. So you see Marlene Ames and Shannon Phillips and David Duvall, and I won't read these bullets to you in the interest of time, but you could read them yourself. You know, all people who were either demoted or denied employment opportunities in the first place, allegedly because they were white, right? Because they weren't gay, because they weren't women, right? These are the cases, not only that we're going to see with increasing regularity and have already seen since 2023, and especially now with increasing regularity, these are the cases that the EEOC chairs has declared as a new enforcement priority. So as Barbara pointed out, what does it mean at the EEOC level? The EEOC can pursue suits on its own. It does not need a private claimant, and you can expect it to put its resources into targeting DEI programs precisely on this theory of reverse, not really reverse discrimination. The last thing I want to say about this, and I'll just move on quickly, is I don't represent, I think Barbara doesn't represent a single client that has a policy that says we're going to disfavor hiring white people in an effort to promote diversity in the workforce and hire more Black people. That would be a blunt instrument. Nobody's policy actually says that, right? Beware, though, and this is not a beware freak out right now. This is more about scrub your policies right now and look at your practices right now. of a so-called disparate impact theory of discrimination. I'm not going to engage in too much of a legal lecture here, but here's the theory. Title VII passes in 1964. What that statute says is you cannot make an obvious adverse employment decision on the basis of somebody's membership in a protected category. In 1970, the Supreme Court, still a liberal court at that time, says, yeah, and you know what? If you maintain a facially neutral policy or practice that has a disparate impact on a protected group, then that equally violates Title VII. So what it meant in the Duke power plant case was there was a bunch of employment-related testing that wasn't actually relevant to job duties that down south had at the time, still 1970, the impact of excluding illiterate candidates who were predominantly at that time in that place in the country, Black. And the Supreme Court said, look, you've got this policy. It doesn't really have to do with job qualifications. It appears to be, and it's a little bit ambiguous. It wasn't intentionally aimed at excluding Black applicants, or current employees for promotional opportunities, probably. But that isn't even a necessary ingredient, right, to violate Title VII. So totally apart from allegations of intentional discrimination, think about what a disparate impact theory means in your DEI programs. Let's suppose you've scrubbed all your language, right? You have a facially neutral, just like in Duke Power, you have a facially neutral policy that says we're going to promote diversity, no reference to race, sex, sexual orientation, or anything else like that. To the extent that it's intended to achieve equity and not equality, and to the extent that that program results in, you know what, as part of our DEI program, we actually are hiring more Black people in a way that we think is good for our business, right? More culturally diverse people, more women in a way that we think is good for our business. Just beware, that could be a target for an aggressive EEOC saying, hey, remember the Griggs case, remember the Duke Power case, right? You've got a disparate impact problem. Your policy might be fine. The effect of your policy, not fine. So this is not intended as a scare tactic, but there's a lot to keep an eye on as we go forward in the future. And Barbara, were you going to address DiPiero?
This DiPiero case, look, these reverse discrimination cases also really come down to basics. If you look at, for instance, the Starbucks case that Mark referred to a couple of slides ago, the female white plaintiff won a verdict because in a situation where I believe there was a demonstration outside a certain Starbucks and it was determined that the Starbucks had not controlled the demonstration, she was terminated, but an African-American manager who had some responsibility for the store was not disciplined. So it really comes down to looking back at basics. And that's where HR is often, as you all know, you're the voice of reason in these situations. Someone might be saying, we need to terminate this person. And you've got to turn around and look and say, well, wait a second, how did we treat this comparative person over here, this person in the same position, in the same circumstance? Put race aside and just make the right decision based on the facts and based on your policies. And this is also an interesting case. Remember I talked about training earlier. So to cut to the facts, as I know we're running a little low on time, plaintiff was a former professor at Penn State. At the time that he sued, he was alleging, and it was true, Penn State was running a lot of different seminars and lectures and trainings for their faculty, promoting the idea of equity and inclusion. And they were running programs on implicit bias and all those types of things. This is like 2018, 2019 through 2022. Professor DiPiero did not like attending these things. He claimed that some of the statements made actually were so offensive to him as a white male that they constituted harassment. And there's the university did a good job of trying to accommodate him, but they did insist that he attend. And that's why I go back to, in today's environment, would I force him to sit through these trainings? Maybe not. Maybe I would give him something to read and say, if you choose not to attend, don't. They did. It was a different time. He eventually resigned and claimed that he was being harassed. And what's interesting, in a very lengthy decision, I think over close to 40 pages, the judge dismissed the claim on summary judgment, finding that sitting through a seminar, a lecture, and academic teaching was not harassment, even though there were some things said in there that triggered him. They weren't directed at him. They were not violating the school's anti-bias policies, and he did not have a claim. So I think that was the right decision. And I think it indicates maybe where some of these things are going to go. So continuing on, looking at gender identity, which of course has become another big focus along with DEI. So we're shifting a bit. So first day in office, he signed an executive order, the Defending Women executive order. And basically what the administration is promoting is there are two genders. Sex is immutable, and the order directed a number of policy changes, including federal agencies had to require government identifications to list a gender. Federal funds could not be used to promote gender ideology. Single-sex spaces in prisons and shelters had to be designated based on gender, and federal agencies had to rescind all inconsistent guidance. And there has been a lot published about these things. So where are we going with gender identity? Well, right now, Bostock is still the law. And that is something that a number of speakers have reminded everyone of in the last few weeks. So what was Bostock? It was a Supreme Court decision authored by Neil Gorsuch, saying that Title VII prohibits discrimination based on sexual orientation and gender identity. Full stop. Still the law. Okay. And in many, many states, including New York, New Jersey, California, I'm just naming a couple, discrimination based on gender identity is still against the law. And the executive order does not impact those states that have specific laws that prohibit such discrimination. So what do you do? I think the bottom line is you do not want to discriminate, but I think you also don't want to make an example of your company. Now, what has the EEOC done? Certainly the federal government is not going to enforce these claims anymore. The EEOC withdrew from, I think, 6 cases, maybe more, where they had begun litigation suing employers who had brought claims for discrimination based on their gender identity. They are mentioning the executive order. And interestingly, they're getting some pushback from judges and from private plaintiffs. So there have been a couple of judges who have declined to immediately dismiss the cases. Basically, the judge's concern was in every EEOC case, there's a private person that was injured. And what a couple of the judges have done is said, wait, I want to find out what Michael or Mary want to do with the case. I don't want them to lose their rights. And then in a number of cases, like this one, the ACLU has intervened. There have also been private groups that have intervened. So I don't think these cases are going away. And again, remember, Bostock is still the law. It's just that the EEOC is not going to enforce them. And this is a map that shows you, and I believe you're going to be able to access these slides, the states that do have laws that prohibit gender identity discrimination. Maybe not a shock, but it's a lot of the what we would call the Democratic states on the various coasts. But then you also have states like New Mexico, Utah, Minnesota, and then the light blue states are states that have. I'm sorry, I can't even see that. What are the light blue states, Mr. Konkel?
So and this is actually interesting. Light blue states, so the dark blue states are the ones that have statutes prohibiting this type of discrimination. The light blue states are ones that have case law, judicial law, so nothing on the books passed by a legislature that comes to the same conclusion. One of the things that Barbara and I find so interesting about this is that if you look at those states where there are judicial interpretations of this, right? We're not talking about, I mean, they happen to be blue on this map, but we're talking about red states in the usual sense: North Dakota, Kansas, Texas, Missouri, Kentucky, Ohio, Florida, right? So just to give you a sense of like, we're not telling you that we understand the landscape here completely. We certainly understand what we understand so far. But the Trump administration has gotten out ahead of, frankly, what the law is in even, so-called conservative jurisdictions. All of this is dust up in the air that it remains to be settled.
Okay, I think the next section is Mr. Konkel.
Okay, so let's talk about, Andrea Lucas again said an EEOC priority, and this is consistent with what we see in the executive orders, is also going to focus on religious accommodations. Now, again, in the past, that might have meant accommodating the beliefs and practices of a variety of religions, but in particular, religious minorities, right? So think non-white, non-Protestant majority that's kind of always been dominant in the United States. Under the current guidance, under the current executive order, it sort of means the opposite. Okay, now the background to this policy shift is actually a shift in the underlying law itself. So in a case called Groff v. DeJoy, the Supreme Court raised a bar that an employer needs to meet to not accommodate somebody. And so for those of you who are familiar with disability accommodation law, which is maybe a little bit more of a well-worn framework, you know, the basic idea is it's discrimination unless you provide a reasonable accommodation, and accommodation is going to be reasonable unless it imposes an undue hardship, which usually means creating significant operational difficulties or significantly increasing costs. Well, the Groff case applied that disability-related standard to religious accommodation. So when an employee says, hey, I'm looking for a religious accommodation, the employer has to do an analysis. Is this a de minimis burden? That used to be what an employer has to show, but that's not good enough anymore. The employer has to show, no, this creates significant difficulty or expense to our business. It creates an undue hardship. What does this mean apart from the theoretical context? So think about this situation. An employee says to you, hey, listen, I can't work on a certain project because that project is ultimately related to some political or social cause that offends my religion, right? And of course, the natural tendency of a lot of employers is to say, yeah, sorry for the discomfort. It's your job. Go do it, right? But if an employer, unless it can show there's significant difficulty or expense to the business in granting that accommodation, pulling that employee off of that particular project, Groff would require the employer to extend that accommodation. So even in Trump's first term, there were executive orders and other press releases about the protection of religious rights. But we now see a much more employment-related direct focus, including through Lucas's initial press release, on protecting workers from religious bias and harassment. So take that hypothetical I just threw out there. Would it be a form of religious bias or harassment to continue to require a worker to engage in delivering services on a project that somehow the worker is claiming are inconsistent with his or her religious beliefs? So this relates back to an executive order that Barbara already mentioned. The key executive order on religious freedom is EO 13798. There are a couple of core components. Government funding of religious institutions. The government can no longer condition government funding or take adverse action on the basis of expression of religious ideas by any individual or house of worship or other religious organization who is speaking about moral and political issues, and in this case, adverse action under the CEO means the imposition of any tax, the delay or denial of tax-exempt status, or the disallowance of tax deductions for contributions made to entities exempted from taxation under those of the 501c3 is simply the tax-exempt provisions for organizations under the tax law. That same executive order relates to abortion, right? Treasury, labor, health, human services, all departments of the federal government shall consider issuing amended regulations consistent to address conscience-based objections to the preventive care mandate promulgated under section blah, blah, blah. What is that a reference to? That's abortion-related services, right? So that specific provision of the EEO seeks to bolster employer arguments that their healthcare plans should not include access to abortion-related services. Some of this happened in Trump 1, and employees would challenge this, and healthcare plans would challenge this as inconsistent with federal law. Those employers who are trying to pull back on extending healthcare provisions to include abortion-related services as a form of preventive care, that gives those individuals and employers an assist. And generally speaking, the AG, the United States Attorney General, shall as appropriate, issue guidance interpreting religious liberty protections in federal law. So expect to see a lot more religion kind of invading the workplace through these avenues that have opened up through the EEOC and the executive order. What does it really mean? Some practical questions, and we don't know the answer. Could a, we suspect we know the answer. Could a wedding planner refuse to provide services to a gay couple looking to get married? Is it a form of religious discrimination to offer abortion services as part of a healthcare plan? Like, what if your healthcare plan does that? Can one of your employees say, you know what, that's a form of harassment or discrimination? It's so profoundly in contrast to what I believe on religious grounds that you're not even allowed to maintain it in my workplace. Or could a company refuse to hire a transgender woman as a receptionist? What if other employees have a problem with a transgender employee on religious grounds and say, you can't put me into exposure with that person? Again, all really troubling, unresolved questions at this point. So I think this is still me. This has worked its way through the courts, right? There's a claim back in 2022, a Catholic RN works for CVS, claims that it violates a religious belief to be dispensing contraceptions, birth control devices to consumers. After years of accommodating her, CVS revoked that accommodation in March of 2022. She was fired when she wouldn't give out birth control medications, meaning the pill. Result, CVS was denied summary judgment. Now, this is in the Southern District of Florida, maybe not a surprising jurisdiction, especially in 2024, but that court held, no, we don't know what a jury's going to find, but that claim can go to trial. There's a genuine issue about whether the law has been violated, and a jury, whether this woman was entitled to a religious accommodation, and a jury is going to need to sort that out. All right, so the slide that you've all been waiting for those of you who want to apply for SHRM credit on the basis of this presentation for 1 credit hour, the claim code is right up there, 25-WWM62, and I do believe you get copies of these slides, so if you missed it, you can check back at that point. All right, so in the final moments here, Barbara, what should employers be thinking?
Oh, look, I think the next slide, yeah, great, the upshot slide. So obviously you have to take this administration, the one before, yeah, right, seriously. Some executive orders will be challenged, they already have been, but the executive orders give you a really good signal into what the EEOC will be doing and what private plaintiffs will be doing. So this moment in time, when we're under an injunction, is actually a moment of several months when you can take the time to review your policies before you're going to be subject to enforcement. If you're a federal contractor, that's a very, very important thing to be doing. I think the EEOC and the agencies that govern you, like the FCC, the FTC, are going to be focusing on diversity. They're going to be focusing on DEI. They're going to be focusing on religious freedom, targeting so-called reverse discrimination. There also seems to be a very real focus by President Trump on eliminating what he views as anti-Semitism. I don't know if you've seen what he has now done or is threatening to do with Columbia University, but if you have any of those issues percolating in your workforce, get up ahead of them. Be honest in looking at your policies. Don't just look at the words, look at how they would be perceived. Look at what's up on your website. Look at programs. I mean, if you're having a program, what's coming up in June is Pride Month. Kelley Drye is going to still have Pride Month events. Absolutely. But we've always invited everyone, and we've never espoused a certain ideology. It's just an event. And we welcome all clients, we welcome all employees. We're going to continue to have events. We continue to have affinity groups, but we've never had a policy that promoted a certain single identity or ideology. We're going to continue to do what we're doing. We have looked at a number of our policies. We've made sure to be clear that decisions are going to be made based on merit and based on qualifications. And that's the best way that you can prepare for this. I said this earlier, avoid quotas, keep workplace programs open to everyone, examine your statistical results, and examine your business. Look at your business. But I do not believe that employers who wish to promote diversity need to go running, for the hills with every diversity program. I just think you need to be mindful about how you do it. And one thing I heard at a recent seminar is when you're looking at diversity programs, consider 2 things. Consider access and effectiveness. Think about it. Access is access to all. So the scholarship, the training program, the group, the program should be accessible by everyone. And then look at the ones that are effective. If you have a program that you've just been doing because it's just been something that you did, but it hasn't been particularly effective, maybe that's one to revisit, but that's based on your business goals. So access and effectiveness. And I think, Mark, were you going to do this one? How employers should prepare?
Yeah, sure. I mean, so this is all obvious. As I said, and Barbara's heard me use this phrase a million times, looking at compliance as the result of the new EOs and the new leadership at the EEOC is like changing the tires on a moving car. The fact is, we all understand in general what the thematic, what the policy shift is. What that means when the rubber hits the road, though, that is going to, we're going to get more data from EEOC enforcement actions. We're going to get more data from the kinds of EEOC charges, and the EEOC does report those statistics that are being filed. We're going to have pursued, right? And employers that are being targeted. Keep your ear to that particular type of ground, because it is going to show you that among these many priorities, really conservative priorities of a new presidential administration, which of those priorities are getting the kinds of limited resources that Barbara was talking about before. They can't fight a multi-front war. What are they going to be focused on? Keep updated. We do have a blog. It's called LaborDaysBlog.com. Shameless plug. Check it out. We post a lot there and are tracking these issues very closely. Barbara's mentioned already, check your policies and your training. And then remember also, not only is the stuff not a license to discriminate, it's also not a license to forget that we live in a federalist type of government where, yes, there's the federal level, there's also the state level. So if you could understand what federal policy is perfectly and comply with that perfectly, you would likely not be meeting all the standards you were expected to live up to. Under state law, that remains an incredibly important area of compliance, and don't forget that level of compliance. With that, we are right up on time. I don't know if we can certainly stick around for a few minutes and take whatever questions that have come up. I don't have a Q&A box open right now because I'm in presenter mode. Barthavi, I don't know if you want to read us some questions. If you don't have a chance to ask questions now, or if you haven't, Barbara and I are certainly very happy to follow up with you after the fact if you want to email us or otherwise reach out to us through C2HR. And it has certainly been Barbara's pleasure and my pleasure presenting to you today. So thank you.
Yep, thank you very much.
Yeah, thank you, Mark and Barbara. I think you gave so much information, people didn't have time for questions. So I think they will follow. Well, as we get questions, we'll definitely share them with you. And we can't thank you enough for your time today and sharing all this information. Thank you again for insight and your continued support as a sponsor of C2HR. We appreciate it.
Thank you so much.
Okay, thank you.